We have a request to move the public hearings and delegations respecting item 8.1, the protocol for gender identity and gender expression, transgender and gender non-conforming persons, following the consideration of delegation requests. Move the consideration of the report to follow the delegations and move the consideration of added item 9.1, a motion regarding the inclusion of report HUR 17002 to the protocol respecting gender identity and gender expression, transgender and gender non-conforming persons, following the consideration of item 8.1. We also have a request to move the delegation respecting item 12.2, the commercial relationship between the City of Hamilton and Canadian Contracting Limited, 4.27, to just prior to the committee going into closed session. We have a revised Appendix A to item 8.1, the protocol for gender identity and gender expression, transgender and gender non-conforming persons. We have a revised Appendix A to item 5.1, the report of the 2016 remuneration and expenses as required under Section 284 of the Municipal Act. We have 13 additional delegation requests, items 4.15 to 4.26, respecting item 8.1, the protocol for gender identity and gender expression, transgender and gender non-conforming persons, and one delegation request, item 4.27, respecting item 12.2, the commercial relationship between the City of Hamilton and Canadian Contracting, all for today's meeting. We have an added motion, the inclusion of report HUR 17002 to the protocol respecting gender identity and gender expression, transgender and gender non-conforming persons. We have an added notice of motion, item 10.1, respecting a development charge demolition credit extension, 849 Scenic Drive, Hamilton. Item 8.1A, which is correspondence, has been removed from the agenda and placed on the March 8th Council agenda.
Councillor Pearson.
Thank you, Madam Chairman and Madam Clerk. I just want to verify we received a number of amendments today, and I'm just going through because we just got them on our blotter, Madam Chairman. I think the residents in the audience should know this. So there's Appendix A revised, but it doesn't highlight what's been revised, and I'm just concerned because without reading both, I can't do a comparison.
Madam Clerk.
I can read out the changes. The revised Appendix A to item 8.1, the amendments include the following. Page 4, item 2.1, removal of the word lived. Page 6, item 5.2, removal of the word of and lived. Page 6, item 5.2, removal of and lived. Page 9, item 3, corrected numbering. Just looking at that. Page 10, item 5.2, removal of and lived. Page 10, item 5.4, removal of first sentence, transgender and gender nonconforming, lived gender identity. That's it.
That's it?
That's
okay.
it for that item.
I apologize. I'm just going to go back to item 3, 3.12 and 3.3. Thank you.
Thank you, Madam Clerk. Are those all of the amendments? Changes? Thank you. May I please have a motion to approve the agenda as amended? Moved by Councillor Pearson, seconded by Councillor Vanderbeek. All those in favour? Carried. Are there any declarations of interest? Seeing none, may I please have a motion to approve the minutes of the February 6th, 2017 meeting? Moved by Councillor Brenda Johnson, seconded by Councillor Aidan Johnson. All those in favour? Carried. May I please have a motion to approve the delegation requests for today's meeting, items 4.1 to 4.27? Moved by Councillor Brenda Johnson, seconded by the Mayor. All those in favor? Carried. The delegations respecting item 8.1, the protocol for gender identity and gender expression, transgender and gender nonconforming persons, 4.1 to 4.26, will be invited to come to the podium to speak at this time. The delegation respecting item 12.2, the commercial relationship between the City of Hamilton and Canadian Contracting Limited, 4.27, will be invited to speak prior to the committee going into closed session. We have many delegates before us today to speak to item 8.1, the protocol for gender identity and gender expression, transgender and gender nonconforming persons. I will be keeping each delegation to the 5-minute time limit as per the provisions of our procedural bylaw. Each delegate, as I stated, will be given 5 minutes and a 1-minute warning at the 4-minute mark. There will be no exceptions. I also hope that today we can prove to all who are watching today's proceedings that our community can speak to contentious, emotional, and passionate issues with the utmost respect of all people, regardless of their views. Prior to hearing the delegations, the committee will be provided with an overview of the report by Bonnie McPhail. Bonnie, can you come to the podium? Bonnie, can you come to the podium down here? Thank you.
Through the chair, good morning and thank you. As Councillor Scully advised, my name is Bonnie McPhail and I am privileged to introduce on behalf of the staff working group and all those people, many who are here this morning, who have contributed their expertise, insight and experiences to its development, the protocol for gender identity and gender expression, transgender and gender nonconforming persons. The report, which accompanies the protocol, outlines its developmental journey and staff's recommendation for its approval. By way of background, in June 2012, what is known as Toby's Law was passed in Ontario with the support of all political parties. Gender identity and gender expression were instituted as prohibited grounds for harassment and discrimination under the Ontario Human Rights Code. Accordingly, the City of Hamilton updated its corporate and human resources policies, procedures, and training to provide staff with direction, education, and awareness about gender identity and gender expression. City departments and divisions developed procedures and practices to operationalize the practical application of transgender rights. In April 2016, there was a legal settlement between the City of Hamilton and a transgender woman about her experience accessing washroom facilities at the McNabb Street bus terminal. In this settlement, the City agreed to put in writing its commitment for persons to access washrooms and change room facilities based on one's self-identified gender, to be addressed by one's preferred name and pronoun corresponding to one's self-identified gender identity, and where possible, to make available all gender single-stall facilities for any person who desires increased privacy, noting that these facilities are not to be imposed upon anyone because of their transgender identity. The development of the protocol has been collaborative and consultative in nature with the following inputs. EGAL, Canada Human Rights Trust, provided expert consultation and comment throughout the development process. EGAL is a national research and advocacy organization for LGBTQ2S communities. Policy research and consideration of best practices throughout Ontario and Canada was conducted by our staff working group. Consultation with our LGBTQ Advisory Committee, who took the initiative of gathering input from representatives of the city's transgender community. A review of numerous written submissions and inquiries received through the mayor's and councillors' offices, as well as through legal services. The Ontario Human Rights Commission has reviewed and commented on the protocol, and review and comments have been provided by Ms. Nicole Nussbaum, a prominent lawyer with leading expertise in advocacy for transgender rights. I am pleased to introduce Ms. Nussbaum, as she is here in the council chambers with us today and available as a resource if needed. Ms. Nussbaum is sitting in the staff row. Thank you. The protocol before you exceeds the requirements of the legal settlement in detailing the city's commitment to transgender rights. In our welcoming and richly diverse city, demonstrating commitment through approval of the protocol and by confirming our practices in our day-to-day operations is the right thing to do. It demonstrates our commitment to our strategic priority of having a cultured and diverse city where inclusivity is embraced and celebrated. The protocol is one piece of a long-term plan which includes informational signage near our washroom and change room facilities, a communication plan, and enhanced training and education for staff about the protocol and transgender rights. On behalf of the staff working group and all of the contributing participants, we thank you for your time and consideration. Thank you.
Thank you, Bonnie. Are there any questions for Bonnie? Are there any questions for the presenter? Seeing none, thank you. The committee will now, reminder that we will be receiving all of the delegations once they have all been heard. I would now like to call Jim Enos from the Hamilton Wentworth Family Action Council to present his make his presentation. And a reminder, you will have 5 minutes to speak, and you will be given a 1-minute warning at the 4-minute mark. Thank you.
That's it, yeah. Thank you very much. So, I mean, in the slides here, so this will work? What do I do? Oh, just by advancing it? Sorry for the delay. We had to set up the PowerPoint. Thank you very much, Donna. Madam Chair, I guess to be appropriate. Sorry, I misspoke there. Removing fences. There is a saying, before you remove a fence, find out why it is there. This makes sense and is applicable to a transgender and gender nonconforming policy, which, if we are not very clear, will remove an existing fence which has been in place for who knows how long. Before we remove an existing fence, let's look at why it is there. Probably the most important place to look, in this case, from a legal and human rights perspective, is in the Ontario Human Rights Code, which is the law. Section 20 of the Ontario Human Rights Code is a section of the code which defines exemptions to various human rights because, as the Ontario Human Rights Commission policy competing human rights states, the courts recognize that no rights are absolute and no right is more important than another right. The law recognizes that laws have limits in some situations where they substantially interfere with the rights of others. The right of a male who self-identifies as female to access and use a public, intimate female facility such as a washroom, change room, or shower is not more important than the right and need of females to be accommodated with these male-exclusive intimate facilities where they can be in various states of disrobing, showering, or carrying out various needs of feminine hygiene without the presence or pending presence of a male. Actually, the right of a male to do so in Ontario does not exist. So this portion of policy now understood, let's look at the relative exemption of the Ontario Human Rights Code, which is the law. Guidelines with respect to facilities by sex. 21. The right under Section 1 to equal treatment with respect to services and facilities without discrimination because of sex is not infringed, where the use of services or facilities is restricted to persons of the same sex on the ground of public decency. Restricting facilities to persons of the same sex is not an infringement of a human right, provided it is on the ground of public decency. This, of course, includes intimate facilities. Females require male-exclusive washrooms, change rooms, and showers where they can feel secure. This is the ground of public decency because invasion of female intimate privacy can be traumatic in various ways. But what about Toby's Law, Bill 33? This Ontario bill did add to the Ontario Human Rights Code gender expression, gender identity, where discrimination is not permitted, as it applies to public facilities such as schools, libraries, parks, etc. However, it did not change the code under exemptions where discrimination is allowed. Specifically, Section 20, subsection 1, outlined earlier. Thus, restricting males from accessing public intimate female facilities is an offence that's not intended to be removed, according to the Ontario Human Rights Code. This fence exists to protect public decency. Is there a need in Ontario for males who identify as transgender or gender nonconforming to access public intimate female facilities? No. The current Ontario Building Code requires new public buildings and renovations of existing public buildings to include 3 types of facilities: female, male, and universal single cell. All persons, regardless of their gender feelings, have the equal right to 2 facility choices: the facility matching the biological gender or the university facility. Allowing some to use a facility opposite to the biological gender is a special right and interferes substantially with the needs and rights of females and males. Should this policy be challenged in the courts, the City of Hamilton must realize that no court has ever ruled that having a 3rd facility is not reasonable accommodation. And no court has ever ruled that full access to opposite-sex intimate facilities is required to satisfy the duty to accommodate.
1 minute, Mr. Enos.
No problem. Thank you very much. A policy which allows individuals the freedom to self-declare their gender and access any intimate facility they choose empowers individuals to self-govern and invade the intimate privacy of others while handcuffing the ability of staff and or police to protect the intimate privacy of citizens who are currently protected under Section 20, subsection 1. We are concerned that our supporters of public decency receive emails from City of Hamilton councillors stating that they agree wholeheartedly with our position on the draft policy, but they feel they are compelled to support it. What kind of society have we become when our representatives feel forced to support policy which is against their moral conscience? We urge the City of Hamilton to adhere to Section 20, subsection 1 of the Ontario Human Rights Code, the law. Do not remove the fence which ensures public decency for females and males in public intimate facilities. I close.
Excuse me. Thank you, Mr. Enos. If we have any more response such as that from the gallery, you will be removed. We are going to go through today's proceedings with the utmost respect for all delegates. Any further outbursts and people will be removed from the gallery. Councillor Johnson.
Thank you very much, Madam Chair, for the opportunity to ask some questions. Good morning, Mr. Enos.
Good morning.
Councillor Johnson.
Councillor Johnson. So I didn't recognize you. I've never met you before, sir.
Before I turn to my questions for Mr. Enos, and I have three, Madam Chair, please allow me to recognize that Hamilton City Hall is on the traditional lands of diverse First Nations, particularly including the Mississauga of the New Credit and the Haudenosaunee, and including in a key way those First Nations Two-Spirit people. Madam Chair, we are honored to have at committee today delegations from the Two-Spirit people of the First Nations. We are also honored to have delegations representing our diverse regional transgender and non-binary communities. To all of those delegations, thank you for coming. Also with us today, we have a large number of cisgender, that is, non-transgender allies. Before I turn to my questions, please let me clarify, I will be voting for the protocol. It is not 100% perfect, but it is an important stepping stone toward true justice in our city. As I reflect on the protocol and my own vote, I remember that this coming Wednesday, the council meeting, where we will be voting and discussing the protocol in final form, is United Nations International Women's Day. I've been thinking a lot about the theme of International Women's Day 2017. The theme is Be Bold for Change. I'm going to preview my three questions, and they are as follows. One, these are for Mr. Enos, and I'll get to them in turn. First question, why should the city reject a protocol that helps us build our economy? Second question, very basically, do transgender people exist? Third question, does the city not have a moral duty to not stigmatize? I'll get to my questions one at a time. So the first question is inspired by the large amount of economic evidence that we now have, empirical evidence, to the effect that cities with thriving LGBTQ2S communities are more prosperous. Economists have offered a variety of explanations as to why it is that cities with thriving LGBTQ2S communities are more prosperous. And there are a couple of explanations that have been offered. The primary explanation is creative workers and professionals generally prefer to live in a cosmopolitan community. That is, communities where harassment is not tolerated and where gender nonconformity is protected. Another key reason is this. When a city chooses to invest its tax money and its mental energy into policing citizens' gender identities, that community has less tax money and less energy left over with which to build a healthy business climate and grow the economy. So my question to Mr. Enos, for starters, is this. In a time of very deep economic uncertainty, why should the city reject a protocol that helps us grow our economy?
Mr. Enos?
Well, it's an interesting question. I've never thought about economical terms. I didn't come here in economical terms today. I came here on behalf of my wife, my daughter, my granddaughters. Their right to be free of invasion of their intimate privacy. So on economic terms, I don't have a comment.
And that's fine, Madam Chair. My next question is inspired by a consistent piece of feedback that I've heard over the past year from our local transgender community through the consultation process that we've been on in order to develop the transgender protocol. Consistently, trans citizens have told me that in their conception, this debate is not about washrooms or change rooms at all. Rather, this debate is about the right of transgender people to exist in public.
Again, if I I understand this is a very emotional debate, but we have 40 people who are going to be making presentations today, and we need to respect all delegates. Councillor, through the chair.
Thank you very much, Madam Chair. The right to exist in public is on my mind because the City of Hamilton is in the business of providing useful public space. Whether it's the Braley Health Centre across the road providing health services, whether it's the McNabb bus terminal providing transit, or whether it's our city pools, transgender people simply do have a right to equal access. However, before we can even think about a right to equal access, we have to acknowledge that there is such a thing as transgender. There are such people. So this is my second question. Does Mr. Enos acknowledge the existence of transgender people?
I certainly do. I had a friend who lived 10 years, a male who lived 10 years as a woman, until his recent passing. A good friend of mine. We spent much time together. I thought no less him a person than any other of my friends. So the answer is yes.
And I don't know.
Councillor, through the chair.
Thank you very much, Madam Chair. I'm glad to know that Mr. Enos has had some lived experience with transgender people. I do not know the preferred pronouns of his friend. However, I'm glad that Mr. Enos had this friend. In light of this friendship, I'm dismayed that Mr. Enos would not want to protect a right to equal access. My final question, Madam Chair, is about violence. We know, Madam Chair, that transgender people, and particularly transgender women and transgender youth, face disproportionate emotional, physical, and sexual violence. And we know that transgender people, particularly including transgender women and transgender youth, make up a disproportionate number of suicide cases. The roots of violence are complex. The roots of transphobia and transmisogyny are very complex, and I don't have time to unpack them all today. But what I do know is this. The City of Hamilton has a moral obligation to never have any practices that communicate to vulnerable citizens, particularly including our transgender women and men and youth, that the violence that they face in society is in any way not inappropriate. Madam Chair, this brings me to my final question to Mr. Enos. Why should the City of Hamilton reject a protocol that helps us to decrease violence against some of our most vulnerable citizens? Why?
Well, that's a fair question. I certainly don't condone violence. You'll never ever heard me speaking for violence or writing for violence. I'm not convinced the protocol reduces violence. When we look at the situation, men and women for many, many years have been required to use facilities matching their birth gender. And there was nothing violent about that, and there was nothing hateful about that. It was a matter of respecting a female's need for intimate privacy in intimate facilities. So I don't tie asking or sticking to the law, the exemption that is in place. The law says that it's not a human right to use a gender-specific facility as long as it's based on the grounds of public decency, which is exactly what I'm presenting today. So I don't tie this protocol to reducing violence.
Madam Chair, that is clear. My interpretation of the law differs significantly from Mr. Enos's, and the moral and legal arguments I know are going to be made very ably today by our diverse delegations. So I'm going to turn the floor over to them after one final word, which is this. As I think about this debate, I'm reminded of Janet Mock's speech at the March on Washington, the Women's March, on January the 21st. Janet Mock, this is I hear Councillor Whitehead murmuring, this is a thought inspired by Mr. Enos's delegation, with which I would like to close my final comment. As you may know, Madam Chair, Janet Mock is a leader both in the black community and the transgender community, and she is a trans woman. In her speech at the March on Washington, she said, quote, "Of the principle of feminism, it requires us to defend one another when it is difficult and dangerous. It requires us to truly see ourselves and one another," unquote. So, to the transgender and non-binary and two-spirit delegations who have come forward today, given that our public spaces are sometimes dangerous and difficult, thank you for defending the moral integrity of Hamilton. Thank you for defending our city.
Thank you,
I'm looking
Councillor.
forward to your delegations.
Thank you, Councillor.
Thank you.
Are there any other, Mr. Enos, are there any other questions for the Mr. Mayor? Did you have a...
No, I don't, but I do want to kind of rain on my friend here with a point of order. So just to be fair, I know Aidan's got a lot of passion for this, as we all do, and I appreciate he wants to get a lot of information out, but I don't think it's particularly fair that we have kind of an ongoing debate with the presenters that are going to be here, because then, for two reasons. One, we're going to be here forever, and there is a debate to be had when the item is actually before us, legitimate. So this is delegation time, and Aidan, but with all due respect, I don't want to, maybe I'm the right guy to do this, but I don't think we should treat all of our delegates in the way that we just did. And we could save all of our kind of debating points for when we get to item 8.1 on the agenda. So if we could follow that rule, Madam Chair, that would be very helpful.
I agree. Thank you, my friend.
Thank you, Mr. Mayor. And Mr. Green, Councillor Green.
Thank you very much, Madam Deputy Mayor. Through you to Mr. Enos. Mr. Enos, should this pass today, what would be your next steps of action?
No, I don't make specific plans. I deal with things as they come up. So that's my honest answer.
Okay.
Thank you, Councillor Green. Are there any further questions for the presenter? If not, thank you, Mr. Enos.
Thank you,
Thank you.
Madam Chair.